thank each and every one of y'all for being here this afternoon. This is an important election, and I'd like to thank the Chamber for sponsoring this event. We've been at it for about 5 months now, 6 months, some of us maybe a little longer, and it's winding down. And for those of you who don't know me, I'm Steve Marino. I'm an attorney from Pointe. I've been there in general law practice for the last 36 years. I'm married to the former Patricia Rockford. Patsy and I have one child, Tyler, who's a medic with Acadian Ambulance.
Thank you, Chamber, for putting it on, and people for coming. I've always felt that a judge should be someone who has practiced for a long time and is well-versed in many areas of law, someone that can be fair and impartial and base his rulings on the law and the evidence without regard for who the parties or the attorneys are in front of him. I've practiced law for 28 years. I've been an indigent defender in this district for 26. I worked exclusively with juveniles for the last 10 years. During that time, I've tried numerous felony jury trials. I've been capital case certified. I've been certified to handle juvenile cases, and I've been working with juveniles for the last 10 years, trying to help them make better decisions and lead more positive lives. We've been successful sometimes we have not been, and that's what it is about. And you have my word, I'm gonna work hard and always try to do what's right. Thank you.
Thank you, Mr. Kimball. Thank you, Mr. Marino, for being here as well. For those of you that do not know me, my name is Lonnie Edros. I grew up in Livonia. I went to Pointe Coupee. After that, I went to LSU, and I went to law school at Mississippi College in Jackson, Mississippi. I'm the proud husband of Paula Edros, the proud father of 2 children, Sam Edros and Kate Edros. Sam is a member of the United States Navy and is stationed in San Diego, California. Kate is a junior at Pointe Coupee. My professional career, I have worked for over 20 years for the District Attorney's Office. As a prosecutor with the District Attorney's Office, I have done many things, primarily prosecuted dads and moms who have refused to take care of their children. That is a crime. I've also prosecuted misdemeanors. I'm also post-certified in highway interdiction, which means seizing drug dealers' assets and money. I have a private practice here in New Roads on New Road Street. In my private practice, I handle a diverse array of litigation, divorces, torts. I've defended the Pointe Coupee Parish Police Jury. I've defended the city of New Roads, amongst different other type of cases. Thank you, Don.
Beginning with juvenile justice, given the perceived increase in juvenile-related crimes, juvenile justice has become a flashpoint in the community. It's a tricky area with a different legal landscape and processes. Ultimately, the object is balancing certain quality of life for all citizens and implementing real reform for young offenders while the reform is still possible and effective, as well as discouraging additional criminal behavior. That said, given the funding constraints within the juvenile justice system, as well as within our parish locally, how do you plan to strike this balance? Or simply, can you explain your approach to juvenile sentencing as it relates to incarceration, probation, and counseling with first and or repeat offenders? We'll start with Mr. Marino, and then we'll alternate from there.
What we're doing currently in Pointe Coupee Parish is we're having juvenile court on a single occasion each month. What I propose to do is multiple juvenile sessions throughout the month. We don't have the attention of some of these juvenile offenders, and we need to obtain that attention. And one way of doing that is incarceration, and that's certainly on the table. But we got to do a better job with our rehab efforts as well. We need to be in contact and communicate with these juveniles on the court basis, so that we can see to it that they're receiving the treatment, substance abuse treatment, educational opportunities that they need to acquire, and just we need more money. There's no doubt there's some relief in sight. that package, that legislative reform that he referred to, that's supposed to reduce our prison population by 10% over the next 10 years and result in a savings of $262 million for the state of Louisiana. 70% of that amount is targeted to come back into the court system for rehab, victim assistance programs, things of that nature. Thank you.
Thank you.
And I'm just to interrupt, if y'all need me to repeat the question at any point, feel free to just request it.
That's what I've done for the last 10 years. And overall, I feel most of the kids we've represented, you give them some counseling, you get them on the right path, and we don't see them again. But you have a small percentage that keep coming back. And the common denominator there is they have no guidance. They have no parental authority, anybody giving them guidance and helping them. I've proposed for quite some time that we need to try and make these parents that are not parenting accountable. And there's laws on the book. Contributing to delinquency of a juvenile and improper supervision of a minor that are on the books that we can hold some of these parents that are not doing what they're supposed to accountable. And there are programs that are in place. You know, I don't believe in just putting a kid in detention just because. You know, I think you got to get him services and try and get him on the right path. If he continues to offend and will not do what's right, then he leaves no other choice. Detention is the only answer. I've seen children go to detention that never made a passing grade in their life. They go to detention and they make straight A's and get all kind of awards. But then they come back and they get back in the home where there's no parental guidance, and they go within a month, they reoffend. And I think that's the biggest issue, is the home life. Kids have to be fearful of something, whether it be the Almighty God or whether it be parental displeasing their parents or discipline of their parents or whether it be incarceration. And I find that the kids that I've represented, they don't have that fear. And we need to instill that fear back in them, whether it be as a community as a whole, that we work to try and get God back in their life, or whether we just, you know, I'll be on top of them as judge. And like Steve said, however many court dates are necessary, you got to stay on top of these kids to keep them in line.
Well, there's been some confusion in the community about pre-adjudication and kids that have been adjudicated delinquent. I've heard it said that there's nowhere to house these children. Don't make the mistake between not understanding the difference between pre-adjudication and a child that's been adjudicated delinquent. Pre-adjudication means before the child has a trial. There is nowhere to house those children, hence the ankle bracelets. Can't set a high bond on the child. You can release the child to the care of the parent for pre-adjudication, but there's nowhere in Pointe Coupee Parish to house a child for pre-adjudication. So then what happens? You have a trial, and if the child's adjudicated delinquent, the state has no choice but to take the child in. Apparently that's not happening. Now, whether they've been given multiple chances or not, I don't know. Juvenile records are confidential, they're concealed. I believe, sure, give them a chance, give them two perhaps. But when they start preying on innocent citizens in our neighborhoods, they have got to be incarcerated. Because innocent people do not deserve to live in fear. It does start at home, there's no doubt about that. And there are remedies against the parents. The Children's Code has remedies against the parents. You can hold the parents in contempt of court in the Children's Code. It's permissible. I've never seen it happen, but it should and can be done. Thank you.
All right. So I think great responses. Thank you again. Y'all have all touched on it, and we've heard complaints about the juvenile system and how it's not been working or not working as effectively as it should. This is a two-part question. In your opinion, what specifically within the controls of this office that you're running for wasn't working well previously, and what specifically do you plan to do differently to change that? And we'll start with Mr. Kimball.
Well, first of all, we have no active FINs. FINs is families in need of services. Just about every other district, I know they have a FINS program, and that's a program that's there to try and get involved with the families pre-delinquent, before the child commits, when they just having behavioral issues. We don't have that in this district. We really need it badly. When I first started doing juvenile work, there was a lady, Ms. Gwen Hayes, that did it and for the district in Plaquemine. She retired and it was not picked up. I think it's imperative that we reactivate FINS. As a judge, I will urge that and urge our community, our police jurors and parish councils to try and re-implement that. Secondly, I've done juveniles in the whole district. There's truancy cases in Iberville and in West Baton Rouge. I haven't had a truancy case in Pointe Coupee in over 5 years. If our kids aren't going to school, they're not learning. We've got to revitalize this truancy program and get these kids in school and hold these parents accountable again that are not sending their kids to school. Because to me, that's a form of abuse. If you're not sending your kids to school, to me, it's just like beating them. You're giving them a sentence that they can't come out of if they don't have an education. Thank you.
Again, I hate to harp on this, but I'm going to. Pre-adjudication and adjudicated delinquent. There have been relatively few trials, juvenile trials, over the last 10, 15 years. They're plea bargains, they put on probation, and they put back into the community. If they're adjudicated delinquent, the state must accept them. And when the state accepts them, then the state, based on a number of factors in the Children's Code, decides what level of secured care they need. It might be a halfway house, it might be a secured facility. But once they're adjudicated delinquent, the state must accept them. Again, I do not want to see first-time offender, 15-year-old going to a secure facility. But a fourth offender has to be taken out of the neighborhood. And from what I understand, there just haven't been that many trials. Now, I know we have a new ADA, Mr. Jeremy Lacombe, prosecuting these juvenile cases, and he informs me he plans on trying these cases, as many as he can, on every court date. And I hope that does occur. Thank you.
Now, allude back to what I earlier said, we don't have their attention at this point in time. We're going to have to obtain that attention before we can even deal with the problems that are out there. And once we get their attention, then we need to do a better job from the bench of recognizing what type of issues these 12, 13-year-old children have that cause them to end up in that courthouse across the street. And until you recognize what issues or problems these children are dealing with, you can't begin to correct those problems or address them in any way whatsoever. And that's what we've been doing. Nothing. We're just moving on, going through the motions. You know, there's a lot of factors involved in juvenile crime. You've got drugs, you've got the interfamily problems of drug use, violence, criminal activity within the family itself. There's peer pressure out there that we didn't experience when we were growing up. Gangs, gang-related crime that's prevalent that we see each and every day. And the violence. It's a different world out there right now. And we better get their attention, and we better take some corrective action. We better figure out how to fix these problems. And rehab, counseling, mental health evaluation, all that has to figure in the school system, law enforcement, certainly from the bench. We have to increase our efforts and re-energize ourselves, and let's get it done.
All right. Well, thank y'all. And with that comes a third part, I guess. Some of y'all touched on it earlier with your earlier statements, but currently the docket for all juvenile cases is restricted to literally a half of a day, 1 day per month. Only after other court business is handled in the morning, often by the same prosecutors. This tends to be less efficient case management, often extends the pre-adjudication time period, again, the time between the arrest and the trial, during which offenders are often able to continue committing crimes, albeit while wearing ankle bracelets. Would you be willing to host the special trial settings or commit to a full day for juveniles to combat this? And if not, why? I'll start with Lonnie.
Yes, the current waiting period between pre-adjudication and the trial is supposed to be 30 days. There's a lot of havoc that can occur in 30 days. A lot of houses can be robbed in 30 days. So I'm certainly not opposed to having more court dates. Again, you know, there are limited financial resources always. One thing that I think would be great is a local probation officer who is in the community, who can visit these children weekly, daily, if they need to. That is allowable under the Children's Code. The state does provide a probation officer, Office of Juvenile Justice, but under the Children's Code, a probation officer, if it can be funded by the jurisdiction, is permissible. And I think that would go a long way in keeping tabs on these children, because like I said, in 30 days, a lot can happen.
I'm in agreement with Lonnie. For the last 6 months, I've been promoting multiple juvenile court sessions here in our particular district. It's just like Lonnie alluded to. He said, you know, you're gonna be there, and then they're released back into that same environment from which they came, and there are multiple crimes being committed. They're participating with the same people over and over. Again, that's one of the answers, but we also have to fix the problem. Again, I know some people like that criminal package reform that showed up this past session, and some have their, you know, some are detractors. But if we realize the savings and that 70% of that 262 million is filtered down like it's supposed to be to us here on the local level, then we can do something about fixing. We can employ the probation officer that Lonnie just referred to, which it does take a lot of effort and take some more money too.
Yes, of course. Welcome more court dates for the juvenile cases, for all cases for that matter. But the judges in our district handle not just criminal, they handle civil docket and whatnot. And historically, they set their calendars. But I've shown through the last 10 years working with juveniles, I've given time in addition that I would be willing to do the same thing as a judge, whether it be outside of court, whether it be going to the schools, whatever it may take. I'd be willing to put in the time. And if it takes a whole day or another day, I'll do so. Juvenile procedure, once a juvenile is held, once you hold him pre-trial, it expedites everything. The juvenile is held in custody, the district attorney has to file a petition within 2 days, and he has to be brought back for answer within 5 days. If they're not held and they're released to the parents, whether it be on house arrest or whatever other type of conditions you put on them, the time period doesn't start to run for the adjudication hearing. Under 877, if they're held, you got to have the adjudication hearing within 30 days, 60 days if it's violent. And that's 877. 854 requires an answer within a certain period of time. So there's a lot of time constraints on the juvenile matters that once you hold them, you've got to do it within a certain time. And I'm fine with setting extra dates. If I got to come back and have an appearance hearing or an adjudication hearing on a child, because I agree, you got to stay on top of them. If you just put them on the back burner and you don't address it, then they're going to keep reoffending. If they're apt to reoffend, they will keep reoffending. I agree.
The next area we're going to focus on is criminal justice reform. So as y'all mentioned, this past year, the legislature passed a comprehensive criminal justice reform package. It's projected to reduce the prison population by 10% and save hundreds of millions of dollars over the next decade. Additionally, 70% of these funds are intended to be reinvested in programs that reduce recidivism and to support victims of crime. In short, the initiative was sold as a way to focus prison beds on those who pose a serious threat to society. So one of the major changes in the additional discretion given to judges when it comes to the sentencing, specifically through the reduction or elimination of minimum and maximum sentencing guidelines. How do you plan to ensure fairness and consistency in sentencing across the board? And, we'll start with Lonnie this time.
First off, I'm not a big fan of some of the reforms. For example, the threshold dollar amount for a felony was raised to $1,000. if somebody steals my $900 rifle, I think it should be a felony. It's not. It's a misdemeanor now. As far as sentencing, I do agree that it's good that the judge has discretion in that regard with a thorough pre-sentence investigation, so you know this person's background, because some people make mistakes, and you should be allowed to compensate or be lenient if you need to for their mistakes. But some people are repeat offenders and make mistakes over and over again. And those persons should get the maximum allowable sentences. I think the legislature would have been better served, if they wanted to save money, is possibly eliminating the life sentence for second-degree murder. Because you got 75-year-old men in Angola right now who committed a crime when they were 25 years old, and they're a liability to the prison system now. It's very expensive to house them. They're not going to get out and commit another crime. The most dangerous age for criminals, 18 to 35 years old. Those are the ones that commit the most crime and the most violent crime. Thank you.
What the 10 bill package did, it basically touched on the reformation of some of our theft statutes that we have out there. I mean, we have theft statutes for stealing a dog, stealing crawfish, and it tried to bring some uniformity to that area. And it also dealt with nonviolent crimes, drug offenses, and the overall effect was lowering some of these minimums in jail sentences. The felony, they talked about, but they soon kicked it out, and they're going to address it next year, and that'll be a classification and grading our felonies. But they didn't want to deal with it this section. They did, and they asked the bucks, and they'll have to deal with it next year. But yeah, each case has to be decided on its own merits. Each defendant is different from the defendant before and after him or her. You look at the rap sheet, see where they are, where they're coming from. I, of course, believe in second chances, depending upon the circumstances. But it's not a hard and fast rule. But again, we've reached the point where these second, third, fourth chances are becoming nothing more than enabling. And it's time to draw the line, and we've got to recognize who these dangerous criminals are before we read about them in the Advocate newspaper that this guy shot this person for senseless crime, and he has a rap sheet that on.
As far as the reform, I think it's good that for the judges to have more discretion in the sentencing, because the judge's job is to look at each case on its own basis. And every case is different. The law may be the same on every case, but every case has different facts. And there's aggravating facts and mitigating facts in every case. And I think it's important that the judge have that discretion in deciding what the appropriate sentence is. And you have my word, when circumstances arise where there's a dangerous person, if they need to be off the street, they'll be off the street. I mean, the judge's discretion in these types of cases, it goes a long ways. If a violent person recommits, there's habitual offender laws that are in place that will ensure that they're off the street. As Lonnie alluded to, with regard to the older gentleman that may have committed murder, there's a geriatric rule that's in place. If someone's in prison for a certain period of time and they reach a certain age, that they're eligible for parole. So there are things on the law already regarding getting elderly criminals that are murderers or whatnot on death row, not death row, but in Angola, out if they meet the requirements and are eligible for parole.
All right. Now, most of the savings are slated to occur in later years, meaning that many of these programs that will not be funded or may not even be around in the near term. How will that, or will that, impact your sentencing approach? So the savings that are slated to take effect as a result of the criminal reform really are going to be more over 10 years and more in the later term of that. So in the near term, with the reforms in place, how are we going to fund, or how is your sentencing going to be impacted by the programs that may or may not be funded or may not be in existence yet?
Well, again, the whole aspect of a judge when he's sentencing is that he's to be fair and impartial, and he's to decide based on looking at the aggravating and the mitigating factors of every case as to what's appropriate for that individual. With regard to, and I'm sorry, I'm trying to follow you.
So say it's a program to reduce recidivism,
Right.
some sort of a workforce training program.
Well,
the
what-
funding
yeah.
for these programs is not slated to actually come in until maybe 5, 6, 7,
Okay,
8 years
I
down
got
the
you.
road.
Basically, with regard to that, when you place someone on probation, they're placed on probation and they're ordered to do certain conditions and whatnot. With regard to the state's supposed to provide those now, if there's not services for mental health counseling or whatever the case may be. Well, again, that's going to fall on the state, because if we probate someone and we order that they get certain services, again, if the state's unable to provide for it because of lack of funding, and again, as a judge, I think if we think someone should be on probation and not in prison, I think it then falls on the state to provide the services that will help reform that person.
I think Kevin's correct in that point. It's a balancing act. You certainly would like to be fair. At the same time, you want to make sure your community stays safe. So if those programs that are to be funded in the future are not yet available, obviously you're going to take that into consideration. So if there's a work release program that's going to be funded 5 years from now, and I'm sentencing my guy today, my guy's going to prison because there's no work release program. So, because ultimately, what you don't want to happen is for someone to get injured in the community. You want the guy to be convicted if he's guilty and to be sentenced to an appropriate sentence, but the citizens of this community need to stay safe.
Absolutely, couldn't be said better. Let me touch on another aggravating element to this problem that we're dealing with. The services being afforded to, for rehabilitation, for reentry courts, things of that nature. You have approximately 40,000 state inmates in Louisiana today. DOC has 7 institutions that have been cut back due to the budget cuts over the past few years. They now have only 7 institutions in which to incarcerate. They are being paid $54 a day per criminal, and with that $54, they receive rehabilitation, drug counseling, mental health screening, counseling, reentry training, GED programs. But take our jail, for instance, and all other local parish jails. They house the remaining 19,000 prisoners. They're paid only $21, less than $21 per criminal per day. That's just enough to feed and house. So that's a failure, and that's got to be addressed. And that's where some of that money has got to be targeted to our local run prisons so that those changes can be made.
All right, so one of the reforms puts limits on the way that restitution is paid or collected, specifically in situations where there's a hardship of the offender. And some see this as severely limiting the victim's right to financial restitution. While the civil avenue is still available to the victim, the outcome will likely be similar in that same situation. What steps would you take from the bench to help make victims whole? So an example, just to, if it were that under $1,000 theft and they only have 1 day a month that they can work to pay off that debt, what can you do from the bench to try to work with the victims?
Well, again, you're right, there are civil remedies, but you can't get water out of a rock. So you can file all the civil suits you want. If the person doesn't have any money, you're not going to get it back. The good thing about the criminal side is that you have some leverage over them then to pay the money back. And you can hold tougher sentences over their heads, probation, revocation over their heads. There are things you can do to incentivize them to do what they need to do to make restitution. It's been a big problem, I will tell you, in our current court system, and it does encourage civil suits. It may not need to occur. I do believe that everyone should be made whole, without a doubt. And if it takes a civil suit to do that, that's fine if the person has insurance. But I think that the criminal justice system should also play a role in it. I believe in civil justice and criminal justice.
You know, that package, that Ken Bill package, it did some changes when it comes to restitution and victim rights. It's depending on the defendant, if you will, his status economically. He can be suspended or allowed not to pay his child support. What has been happening in prison, and you have a child support judgment existing out there, that thing continues to run. And you know, once you get out, you got to make that up. You got to catch it back up. But they're going to do away with that to a great extent with this package. And they say it's because this individual needs better an opportunity, get on his feet so he can get into the workforce and mainstream his life, and he won't be back in jail again. Well, that's got some merit to it as well, but we also need to think about self-responsibility, accountability. They got themselves in that predicament, and somebody took care of those children while he was in jail. And that was lost on that legislature this past year. Some approaches were good. They did with the furlough for medical assistance when there was you would be in need of medical care. They would allow that inmate to go off premises, and Medicaid would take care of it, and that would save money for the state. There's a lot going on there where they're trying to help get these people re-entered into society, and some of it I agree with, some I certainly don't agree with.
I don't really agree with that part of the package, the restitution part and the part that restricts the judge's right to revoke someone. If you put them on probation and you give them certain conditions and they don't abide by it, I think the judge ought to have an authority. I think the act restricts a great deal what a judge can do to his probation, like with the court if he doesn't pay restitution or if he doesn't pay his fines and fees. And I do disagree, but unfortunately, as judges, whichever one of us are elected, we're going to be bound to follow it. And we may be restricted from revoking someone when we feel that they've not complied with our conditions.
Thank you.
I wanted to add something off. I know it's against the rules, but on the child support issue, and I'm sure Steve knows this, they did tack on to the number of years that you have to pay child support the length of time you were incarcerated. Before the change in the law, the child support continued to run. Now, it can be tacked on. Normally, it stops when they're 18 or graduate from high school. So they could be paying child support to the child's 25, 26, 27 years old now. So that change was okay, but they probably shouldn't have changed it at all.
All right. Thank you. So I guess you've also, all of you kind of touched on this. Do you think that the reform has gone far enough? Has it gone too far? And I guess in other words, which future changes would you like to see, or what changes would you like to see to the current reform package? I think actually Mr. Marino.
Well, a lot of that would depend on if we're going to realize that 70% of that $262 million. You know, it's programmed where it's going to supposedly reduce our prison population by 10% over the next 10 years, and that's going to result in that savings at $54 or $21 is being spent per inmate, depending on where he's situated. You know, I know the District Attorneys Association, the Sheriff's Association, Lobby, Family Forum, they all finally got together on this package, and you know, it's needed. It was needed. We need to reduce our prison population. We incarcerate more people than anybody in the world. You all know that. But then again, you know, we also lead the nation in murder rate. We kill 5 people for every 100,000 people. The national average is 5 people. We're not doing the job that we need to do to rehabilitate these people. We need to recognize these aggressive, violent criminals, get them off the street, get them off the street. You know, I don't know if we touched on the package where we're dealing with juvenile lifers. Are we going to deal with that later on?
I don't know.
Because, you know, previously we were... There are a number of juveniles who were sentenced to life without the opportunity for parole. That has been changed now. The Supreme Court said that was unconstitutional, and we've done our packaging in this legislative session that you've got to give them an opportunity for parole hearing within 25 years of their incarceration.
Steve's correct, and I do agree with the United States Supreme Court said it was unconstitutional to imprison a 17-year-old for life. I'm in agreement with that. I think a 17-year-old that makes a grave mistake should at some point in his life have a chance to get out and prove that he's fit to live in society. One thing that I am not in favor of is keeping, and this is a legislative thing, but I think that's really what your question is. I'm not in favor of keeping a 70-year-old man who committed a crime when he was 25 in prison for life. Maybe some of them, not all of them. And unless they have serious medical issues, and that's what Kevin was talking about, the legislature made an exception for medical for a while. Unless they have serious medical issues, they cannot get out. I think there ought to be an opportunity for the elderly in prison, even if they're not sick, to get out. And that would save a lot of money. Again, most of the violent crime in this country is committed between people 18 to 35 years old. Once you get over 50, you wisen up a little bit. Most of us do anyway.
I think we got off topic a little bit, but since we own it, juvenile life, yes, that's that U.S. Supreme Court case that said that it's unconstitutional. And what they're talking about is juvenile cases, kids that are 14 or 15, that they're transferred from juvenile court into district court and tried as an adult. And the Supreme Court found that that is unconstitutional. I agree with that. Because there's plenty of studies on the juvenile brain and their development. And all the studies point towards that a child, an adolescent's brain is not fully developed until such a time, and they don't appreciate the risk associated with the actions until they reach all the way up to like 24, 25. And so I think that's a lot of what that case was based on, the fact that these kids, while they may be intelligent, they may make straight A's in school, they still don't associate the risk with their actions. And I think that's a good case, and I believe that juveniles should not be held in life without parole. And with regard to the act, which was I think the initial question, I agree with lots of it, you know, but I don't like the part that ties the judge's hands, because we're the ones hearing the case, and it's our job, you know, to look at the case and the facts of each case and decide each case on its own merits. And I think, you know, the act in some sense restricts what a judge can do with the probation officer, and that part of it I don't like.
Just on that subject, and I'll be brief. That change does allow for an exception for the worst of the worst offenders with no hope or opportunity that you can rehabilitate that individual. There is an exception.
All right, and similar, I guess, when we're looking at alternative and reform, one of the things that has become more popular or prevalent recently is drug court. Where do you see that, or what role do you see drug court playing in your courtroom? So we'll start with Kevin.
I've worked with the drug court both in Iberville and here, and I truly believe in the system. I think it's a good program. I mean, it's based on you try and keep the person that's addicted to drugs busy so that they don't have time to think about you know, using. They have to have a job. They have to report for testing every week. They have to go to counseling every week, and I think it's a good thing. But I can tell you, from my experience in drug court, both here and in Iberville, an addict, until he's ready to change, you can send him to 100 rehabs. They have to want it here. And I think that's where my role as a judge, I think that a lot of times the threat of incarceration is one of the greater things that will make an addict based on using, say, it's time for me to change. And I think that it's kind of, you know, as I said earlier about fear, there's no fear in these juveniles because they don't have fear of God, they don't have fear of imprisonment, they don't have fear of their parents. Same thing goes for an addict. And that's the root of all evil, I think, in our society. Because most of these addicts, they're stealing, whether it's a drug offense or not, they're stealing to get drugs, or if it's a violent offense, it has something to do with drugs. And I think that's where we really need to push to try and help those people addicted to drugs, try and get them help. But at the same time, if they don't want the help you're offering, an alternative would be jail.
Like Kevin, I'm a firm believer in the drug court. I think the drug court in Pointe Coupee has been successful, and I'd like to commend Judge Best. He instituted it and it has worked well. Again, addiction has touched probably every family in this room in some form, and it's hard to understand. It really is. So you don't want to lock up somebody who has a drug problem just because they have a drug problem. At the same time, when they start stealing from their grandmother to buy drugs, which happens, we all know it happens, then there has to be consequences to it. So the drug court is great because it allows them to try and get clean, prove they can stay clean. At the same time, it also gives them the opportunity to fail. And once they fail, they must be incarcerated.
And we all know that drugs, that's the fuel for crime. We've been dealing with it. It's the opioid deal that we're dealing with right now. It's the drugs that are out there right now are much more potent than what they were 10 years ago because they're economical, if you will. And so that's the drug of choice right now. We need to expand our drug court efforts. We've done a wonderful job here in Pointe Coupee. Judge Best has indeed done a wonderful job creating that court and running it. We need to expand. The alternative to drug court, and more often than not instances, that's the jail. So we already know what that's costing us. You know, and I agree. Drug addiction has impacted probably every family in this room. It certainly has mine, and it's something that's not going to go away with on its own. We need to treat it for what it is. It's a disease, but again, just like Lonnie said, that once it carries over into crime, where there's stealing, there's violence, breaking and entering, all of that stuff, we have to draw the line. We have to get their attention. And there is a penalty to pay at that point in time, and that's incarceration. But again, I'm all in favor of people receiving the treatment that they need, and it's a duty of ours, as judges, that we would see to it that they get that help.
Hear with me a minute about drug court. I agree totally. If you're on probation and you reoffend, yeah, the option is you should, especially another felony. Typically, you're looking at revocation. But the drug court system, the way it's set up, I just want to clarify, it's set up on sanctions. And just because you might test positive while you're on drug court, you're not automatically revoked. I mean, there's sanctions set up. The judge has authority to revoke, but typically what they do is, again, they were trying to work with this person, because addiction is a battle. They expect them to reoffend. They expect them to relapse. First one, they might get a weekend in jail. The next time, they might, you got to go to inpatient treatment. There's a bunch of sanctions in place in drug court prior to revoking. Of course, at any point in time, the judge has authority to revoke if he thinks that the offense was sufficient enough to.
All right, not a problem. All right, so switching gears a little bit more to the civil litigation side of things. The U.S. Chamber of Commerce Institute for Legal Reform recently named Louisiana as having the worst lawsuit climate in the nation. Additionally, 85% of senior business executives at major U.S. companies surveyed said that the legal climate impacts decisions on expansion and growth, economic development essentially, which is obviously a huge focus of the chamber. One question of the survey, where Louisiana ranked 50th, was the trial judge's competence. Given the breadth of items that'll come before you, how do you plan to improve that statistic? Because we're also 50th in the quality of the appellate review.
As I said earlier, I believe in criminal justice and I believe in civil justice. Civil Code Article 2315 is a civil code article that allows you to file a tort lawsuit. One thing that does not happen enough is sanctions. A lawyer can be sanctioned for filing a frivolous lawsuit. There are consequences for it, and I will tell you, I've been practicing 24 years and I may have seen it once. I don't actually recall ever seeing a lawyer be sanctioned for filing a frivolous lawsuit. However, I've practiced a great deal in federal court, and I'll promise you, there aren't too many frivolous lawsuits filed by attorneys in federal court. There's a rule called Rule 11 in federal court. If you file a frivolous action in federal court, the federal judge would be glad to talk to you. The judges here have the same authority. Our civil code mirrors the federal civil code a great deal. And the judges here have the authority to sanction an attorney who files a frivolous lawsuit. On the other side of that coin, however, is that there are legitimate lawsuits. People get injured through other people's negligence, and they have a right to be made whole. I fully believe that. But I also do not believe in frivolous lawsuits.
Certainly, I don't believe in frivolous lawsuits as well. We are probably the most litigious state in the union, and I think we all know that. Recently I read where, and I knew this, that we have a $50,000 threshold for a jury trial, and that's number one in the United States. And the second most is $15,000 threshold. I think it might be Massachusetts, somewhere up north. But, I have practiced in the personal injury arena for some 20 years now. It was ugly then with the frivolous lawsuits and the back and forth. The insurance, they have to shoulder some of the blame as well because they fostered some of this. When you come in there with your famous whiplash case, and they'll sit there and they're going to settle it. They're going to give money instead of paying an attorney to try it because it's economically, they're looking at the bottom line. It's more feasible to pay it, but you created the monster, and the monster still exists in the form of frivolous lawsuits. But again, that being said, certainly everyone should be made whole if they are harmed by any other person or corporation or whatever. And I'm certainly in favor of that. I would be fair and impartial. But again, I'm like Lonnie. I have no taste for these frivolous lawsuits, and that's one of the reasons I got out that arena. I just didn't want to deal with it anymore, and I moved on to certain other areas of the law, and that's where I am today.
Again, frivolous lawsuits are not good. I agree with that. I do believe in a person's right to seek to be made whole. I think to go back to your answer about where our judges rank, I mean, the answer to that is to prepare. I think in a lot of instances, we all practice various areas of law, and we are well versed in some areas, and others we're not. But as a judge, it's our job to prepare, just like an attorney, for the case coming in before you. And I'm going to work harder as a judge to always be prepared for every case that comes before me. I'm going to know the law, and whatever I need to read to be up to the law on that particular case, I think that's what's important. And I don't want to point at any of our judges, because I think we've had a good group of judges. But as far as our rank, I don't know why we got there, but could it be laziness? I don't know. But you have my word that I'm going to work hard every day. I'm going to do what I can to prepare and be ready for the case that's coming before me that day, whatever. Even if it's a case that I haven't done a lot of personal injury stuff in my career. I've done some early on, much like Steve said, but it got to the point where it's very difficult to get those cases anyway, because a lot of these lawyers, as they call them, ambulance cases, get them and whatnot. I think there should be some sanctions I think there should be some control on advertising by lawyers. I think there's too much advertising. That has nothing to do with it. But at the same time, I believe in sanctioning people that file frivolous suits, and I also believe in a person's right to be made whole.
So the next one, I think y'all kind of jumped the gun on me, but lawsuits, and especially frivolous lawsuits, are disproportionately expensive for small business. And a common complaint locally is the limited use or delay in summary judgment or dismissal or sanctions. Do you plan on moving the needle in these areas, and how?
Well, let me tell you, first of all, that the burden of proof on the summary judgment motions was amended about 10 years ago. When I first started practicing, summary judgment was disfavored. And for you lay folks out there, summary judgment is a way for the case to be dismissed prior to trial. So the law changed when Mike Foster, I think, was in office, from being disfavored, and now summary judgment is favored. So a lot of cases are now dismissed on summary judgment. Back 23 years ago when I was practicing, it would not have been. Again, frivolous lawsuits usually don't make it through that phase. Steve touched upon it. The insurance companies on these, they're partly to blame too, because they make an economic decision. Are we going to fight this $3,000 claim, or are we just going to pay it? And large, because it's going to cost them more than $3,000 to defend it. So they'll just pay it. So that just adds fuel to the fire. But the summary judgment law is a good law, and it was changed already in the tort reform that Mike Foster instituted. What was the rest of your question there?
I guess, how do you plan to move the needle? Or do you plan to move the needle, so use those tools more often, and how?
I plan on being fair. So whether being fair benefits the plaintiff or defendant, that's what I plan on doing. So if the plaintiff is been injured by the fault of a defendant, I'm going to rule for the plaintiff. If the defendant has zero fault, I will dismiss the case. So all you can do is be fair.
That's right. You have, without question, it comes down to fairness and being impartial. You need to listen to the evidence. Each case is going to have to be decided on its own merits. Each case is different. You know, we have to apply the law that's been provided to us. We have to use the correct application of that law and interpret that law correctly. We have to apply the facts as we interpret them to be, and we make our decision accordingly. And as long as we're fair and impartial and we listen to both sides, and it'll work out. But I mean, we're really not changing a great deal here. We just need to apply the law that's available, and it's ever changing. It changes all the time. You know, and we have to stay cognizant of those changes. But again, you know, we're not going to ride off into the West with some new approach or silver bullet at this point in time. We have to apply what we have, and that's mandated. We have to do that. But we need to take time to listen to both sides, understand what we're hearing, what evidence is being presented, and that's the only evidence that you consider, is what's properly before the court that particular day. And that's the best thing that a judge can accomplish, is knowing at the end of each day that the parties that appeared before the court that particular day have departed knowing that their matter was decided in a completely fair and impartial manner, that the evidence was properly before the court, and the correct application of the law was applied.
Arthur, I'm going to grant your wish for an answer shorter than a minute. I agree with what they both said. I don't know that I need to keep going on it, but I'll say this. It's about being fair and impartial. It's about looking at the facts in front of you and basing your decision on what's in front of you and nothing else. And, you know, that's what a job for the judge to do, whether it's a summary judgment or whether it's the final ruling. And I think that's it's incumbent on us to do what we feel is right in every particular case and based on what's before us. We shouldn't let anything outside of the evidence that's been introduced factor into our decision. It's all about being fair and impartial.
Many judges, former and current, have traditionally used a cattle call system under which all cases, sometimes 20 or more, are scheduled to be heard at the same time on the same day, usually at 9 o'clock in the morning on a particular morning of the week. This often leads to hours of sitting around and waiting by litigants, witnesses, attorneys, resulting in much wasted time and unnecessary attorney's fees. Do you plan to continue using the same system, or do you plan to promote a more efficient method of docketing cases? Please explain specifically how do you plan to hold rule day scheduling.
If anybody's been up there on rule day, they know what you're talking about. It's back and forth. It looks like organized confusion. The tail is wagging the dog in many instances. It's a lot of negotiations going on at that point in time. But that needs to be streamlined. We need to start working at a set time. It's 8:30 or 9 o'clock. We need to begin our court sessions at that point in time. And we need to work a full day if necessary. Now, I tell you, tomorrow is Friday. You can go up in that courtroom tomorrow and you might die of loneliness because you're going to be the only one there. And that's more often than not. There are some days that we work 40 hours a week and you'll see it. But there's ample opportunity for us to get the work done that needs to be done. People don't want to be coming back 2 and 3 times to have their matter determined, whether second setting or whatever the case might be. When we say it's time to go to work, we go to work, and we stay working until we finish. And I remember when I first started some 36 years ago, and we wouldn't leave the courthouse on many occasions, for instance, on rule days, misdemeanor days. Sometimes they were combined, and it might be 7, 8 o'clock in the evening. You don't see that much anymore. At least I haven't participated in any of it in the last 10, 12, 15 years or so. But, we just need to work hard to pay attention to what we're doing. Back and forth has got to be curtailed. If you want to make your deals, you better do it before you show up there that day. Everybody's got a life to live outside that courtroom.
With regard to whether I'm going to change the system, I think in some cases, yeah, and it depends on the attorneys and the people. If they want a later date or later time to come and whatnot, I would be for accommodation, yes. I'm for working a full day. One thing I would look at, I'm not sure currently, drug court, what time do they have it? Anybody know? Like 3, because when I was doing it, I haven't done it since I've been on juvenile, but they used to do it in the morning, and I thought that was, I didn't think that was good. I mean, you're making the drug court participants work, and a lot of times you got to make them have a job. I think drug court would probably be better suited in the afternoon after they get off of work. Oh, you are now? I didn't know if you changed. Okay. Okay, because when I used to do it with you, we did it in the mornings, and I always thought that was not good because you're asking these people to maintain a full-time job, but yet they got to miss 1 day a week to come to court. But to answer your question, Arthur, again, yes, I'd be looking at if the attorneys ask for a later time period so they're not waiting around. Yes, I would not have a problem with staggering the docket and doing that. But I think in a lot of cases, that's your opportunity to meet with the other attorney and try and iron out your case. I would be for myself taking the bench promptly at the time, calling the roll, who's ready to go, and if people have their cases ready, we'll deal with it. If they need more time to work it out, a lot of times the judge will take a recess and give them a time to try and finalize whatever cases they have. But again, I think it's more about working with the attorneys in your district. If they would like a later date, not a 8:30 start time, then you're trying to accommodate.
Well, I've handled a great deal of civil litigation in my career. That's primarily what I do. I represented defendants, City of New Roads, Pointe Parish Police Jury. I represented plaintiffs. And I write briefs, which is something I hate doing. Once I start doing it, though, I get into it, and I get in the rhythm of it, and I get in the flow of it, and I'm like, wow, I'm a genius. It sounds great. And I get it hand-delivered to the court, put it in the law clerk's hand. And I get there the day of court, and the judge looks at me and says, did you write a brief? And I want to run up there and choke him, because I spent 3 days working on the brief. So I will tell you, and Judge DuPont was great about this. He would get there at 7:30 in the morning. He would read everything, and that's what I plan on doing. I will read everything that is submitted to me, And that saves time. And the reason it saves time is because if you read the brief, you know about the case. Before the lawyers even step foot in front of you, you know what's going on. And it saves time because you don't have all that back and forth, back and forth, back and forth between these attorneys. You can shut them down. Say, I've heard enough. I read your brief. And if I seem animated about this, because I spent many, many nights till 3 in the morning writing a brief, because I hate doing it, but I do it. And when I'm finished with it, I look at it and I'm like, that's a work of art, but it's probably really not. That's just how it is. And there's nothing more frustrating than you getting there and the judge did not even read the brief. So I will read everything and I will work hard.
So again, this is going to be something that I think y'all touched on. Some judges are, for lack of a better word, accused of working only part-time because they finish their docket in the mornings and take the afternoon off. Do you plan to docket cases for a hearing in the afternoons as well as the mornings? And again, looking for more specifics on the docketing proposals that you're mulling over.
Again, I would have no problem with it. And you know, I think I've demonstrated that over the last 28 years practicing law, that I've put in the time and I've worked hard. I've always been prepared when I've been in court. And as a judge, as I alluded to in one of the earlier questions, I'm prepared just as hard, if not harder, as a judge to be prepared on every case that comes before me. Because you're not just sitting up there looking pretty. I mean, you got a job to do, and you need to be prepared. You need to have read Lonnie's brief, and you know, and I mean, I agree with it, though, 100%. I mean, judges need to prepare just like the attorneys do for every case, and I don't know that that's always been the case. I'm not pointing at anybody, but you have my word that I'm gonna work hard. I'm always be prepared, and yes, I'll do docket cases in the afternoon if needed.
There's really nothing more frustrating than exactly what Lonnie described, is that you put that work in, that effort, and you know, you're trying to support your position, and time after time I've encountered judges that you know, you ask them if they've taken a look at your brief. No, where is it? Well, it was sent to you a week ago or on the deadline date, and it's a lot of wasted work, and it would condense a lot of matters. It would shorten a lot of matters because you'd have a grasp on, or the judge would have a grasp on what's going on. He wouldn't have to be rubbed through it, taken by hand, and explain step by step what's going on in the matter. But yes, I would certainly be most in favor of increasing the docket. But we also have to be careful that we can finish that docket, because we've got a lot of people showing up that day, more than we would have before. And if we don't get through our docket, we wasted a bunch of people's day, and we've got to avoid that. So it's a balancing act, you know. We got to be somewhat flexible, and I'm sure it's going to be a learn as you go situation, and because I've sat there along with a number of other attorneys and parties and watched a simple matter drag on for hours, hours, and hours. And that's what we need to be careful about. We need to be able to move those type cases along, but we can't be wasting people's time, because what's before that court is too important to ignore or to just give a brief listen to in making a decision.
I think I already spoke on it.
I'm losing track. All right, so this is the last one. We'll kind of kick a dead horse. The general public expects an honest day's work for an honest day's pay, from their judge especially. Know that most civil trials get settled on the eve of the trial date, thereby freeing up time on the court's docket. How do you plan to docket cases to make the most efficient use of the court's time and keep the court docket from clogging up and backlogging? Obviously, there's a little theme here. So
sure. In my private practice, I get it to work every day at 7:30. I stop at the LA Express in Gyro, which is where I live. I get a cup of coffee. I'm at my desk at 7:30 every day. I do not intend to change that routine. I will be at my desk at 7:30 in the morning, every morning, in this courthouse. That is my plan. I will stay there until 4:30, 5:30, 6:30 if necessary, as much as it takes. I will read everything. I like to read. I like interesting cases. I like learning new things. So I look forward to this position. I don't look at it as some easy job that I want to step into. I look at it as a challenge, something that I look forward to doing, something that I can do a good job and improve this community.
You know, that's part of the equation. It's hard work, commitment, and no doubt, the three of us are all on the same page there. I've watched these two gentlemen for many, many years, and they're hard workers, they're good friends, they're good, honest workers, and they're very proficient at what they do. When we have to work hard, we have to show up early, we have to stay late, and I'll be over there on Friday afternoons if necessary in that courtroom. And again, but we have the docketing issue that we have to be mindful of our citizens and their time. It goes back to, you see it on jury duty as well, and there's some of that's unavoidable. You know, like it was alluded to, you said that you know, a lot of these matters settle right there at the courthouse door, and that's true. You know, you would hope, and you would. And the attorneys here are pretty good with this, that, you know, as soon as the case is settled 1 day out or 2 days out, that they're going to contact the judge and let the judge know that this matter is settled. They'll be submitting whatever documentation they need to submit to finalize the matter. But, you know, certainly we need to take on more matters. We need to get the work done. There's nothing wrong with 40 hours, and there's nothing wrong with 50 hours or 60 hours a week. If that's what it takes, I'm willing to do it.
I think basically to answer your question about the docketing, if you got a trial set, typically you would set another trial behind it and tell them to be ready in the event the other one can't, you know, were to settle. And I think, you know, of course, you got to get people subpoenaed and everything, so there's a cost you got to look at. But I think as long as you let the attorneys know, hey, I'm putting 3 cases on my docket. If the first one goes, y'all won't go. But it's imperative on the attorneys to also be involved in it and let you know, are we going to settle this? Is there a chance of settling it? So the second case will know that they need to be ready to go because the other case is very likely going to settle. And really, majority of cases do settle, you know. And so I think for the most part, to save time, you would book more than one case on that docket. It's just the second and third one will know that they're not going to go with the first one.
So Fridays are going to be busy at the courthouse, sounds like. All right, switching gears to local politics. Judge Vest referred to this as one of the most controversial jobs that a human being can have, and for many reasons. We live in a small community, and the law community is even a smaller group of people within that community. Where do you draw the line in determining whether you should recuse yourself from a case? And please be specific.
Well, there's a statute that sets out certain requirements when you must recuse yourself. But there also in that statute, it says if you believe you cannot be fair. And that's where the line is drawn. So if it's someone that you're really is a close friend of yours, and you know that there's no way you can be fair, you must recuse yourself. It's unjust not to do it. At the same time, just because your friend's cousin brother is asking you to do it, no way. Because then you wouldn't get anything done. So you have to make hard decisions. You have to take cases you don't want to handle, and you have to bite the bullet and do it. And you're going to make people angry. You're going to get phone calls saying, hey, why don't you do this to my cousin? Well, because your cousin robbed Walmart. That's why. So you got to take a stance. You got to make tough decisions, and people are going to be mad. But that's just the way it is.
Right. You know, it's spelled out in the recusal statute, and certainly, you know, we have to adhere to that. But again, like Lonnie stated, that you know, everybody in Pointe Coupee, for the most part, knows most other people in Pointe Coupee Parish. So you're going to always deal with that issue to a certain extent. But once it falls under the elements set forth in that statute, then you necessarily must remove yourself from that case. And if, you know, if somebody has a problem and you haven't done it, they have the party can file for recusal on that particular judge. So, you know, there's protection there, but again, it all comes back down to fairness, being informed. Simply that.
I agree with what they said. I mean, I want to handle every case that's docketed to me. But naturally, if it comes down that it's a case that I do not feel I can be fair, I'll recuse myself. And if an attorney feels I can't be fair, he has a right to file something asking me to recuse myself. If I refuse to, another judge will hear it. I mean, it's all in the code. And I mean, again, plain and simple as they said. If I don't feel I can be fair, I'm not going to handle the case.
All right. Similarly, you're undoubtedly going to be asked to preside over a case of political importance, or one that involves political figures or with potentially significant political fallout. As an elected position, it's a difficult spot that you're in as a judge, and a recusal is sometimes viewed as the easy way out. Will you reiterate, I guess, where you draw the line in this situation?
Again, if you can't be fair, you can't hear the case. But there's no reason, unless you have some special relationship with this elected person, that you shouldn't be able to be fair. I mean, particularly with elected officials, they entrusted with the public. The public has trusted them, and certainly you don't want to shun your responsibilities as a judge because the public trusted you as well. So whether it's a public official or somebody, you know, cleaning the streets, it doesn't matter. You have to treat them all the same. You can't treat anybody differently because they're a public official or any other status or job that they might have. Everyone has to be treated fairly and treated the same.
I agree. I mean, it doesn't matter who the parties are in front of you. And really, you know, we're all taking this job or trying to get this job, and we understand that there's going to be hard decisions that need to be made, and there may be fallout from it. But you have my word that I'm going to rule based on the law and the evidence that's in front of me, and that's it. If there's a fallout from it, so be it. You know, if I make a wrong decision, that's what the Court of Appeals is for. You have my word. I'm always base my rulings on the law and the evidence on a case-by-case basis, and that's what we as judges are bound to do. And so, to answer your question,
Well, just about anything you do from up on that bench, there's going to be some controversy. Somebody's going to walk out of that courtroom happy, and somebody else is going to walk out of there not so happy. But the fact that someone is a politician or is involved in a case, you know, an elected official, that's of no import at all. If I had a special relationship with a particular politician, that may force my recusal because I couldn't be fair. But I'm going to assure you that that's not going to happen. You know, we also have to avoid the appearance of impropriety as well, and we have a certain judicial standard that we need to adhere to. But again, it comes back down to this. We treat everybody the same way. Listen to the facts. Doesn't matter who the parties are, and you interpret the facts properly and you apply the law correctly. Make sure you're fair and impartial with everything that you do from that bench. It's an important job and it's a difficult job, but as long as you take the high road and you do what's right, we'll get through it. And we won't always be right, but like Kevin said, thank God for the safety net, the appellate court system, and beyond. But you know, we're going to make mistakes up there. I'm going to make mistakes up there if I'm fortunate enough to be elected in this election. I know of no judge that hasn't not made mistakes on the bench. So you know, we all going to learn as we go. There is a certain level of learning that we'll all have to deal with. But again, as long as we are in good faith and impartial, it'll all work out.
All right. So the last question of the broad questioning, I guess. If you're elected for this partial term through 2020, Do you intend to seek the seat for the next full term, and how many terms do you plan on filling this role?
First off, I'd like to say I'm not going to make any mistakes. It's a joke. Everybody makes mistakes. Mr. Marino's correct about that. All you can do is try your best, try to be fair, and that's it. Yes, I do intend to run at least one more term after that. I'm 52 years old. That would put me out about 62 whenever the second term would be up. I don't know that I would do it beyond that. I might. I haven't put much thought into that. But I do believe I would run after this 3-year short term is up. Look, this job is important, and I'm glad that we're having this forum tonight. This is a job that should not be taken lightly. It impacts every aspect of our community. And I live in this community, and I would like to see this community taken care of, and that is why I'm running for this job.
I agree. I think, you know, state it again. He got me off track with his last.
Yeah, and there will be time for closing statements after everything. But no, so you've got a partial term this time around. Do you plan to run for the full term?
Again, at least one, maybe two. You know, being a judge is not something I've wanted to do it for a while, but I always felt I wasn't ready. You know, many years people said, "Are you going to run? You going to run?" And I said, "No, I'm not ready." "Well, why are you not ready?" "He's running." I said, "Well, that's him. It's not me." But over the years of practice that I've had and the experience I've had, I feel I'm ready to serve. You know, all we have in this world is recent things made me think about it is what we leave behind. And I would like to make our community better than what it is currently. You know, I think we do have a problem with crime. I think we do have a problem with juvenile crime, and that's where I've worked hard for the last 10 years. And you have my word, I'm going to continue to work hard on the juvenile crime because they're our future. If we can't get these kids on the right path, then our future is quite bleak, I'll be honest with you. And you know, there's things that I've done in the juvenile system that I'd like to implement that I think as a judge I'd be able to help them even more. Thank you.
Well, it would only be one time that I could run if I was elected here because of my age. I'm 64 years of age. And I would only be, if I was fortunate enough to get elected to this partial term, I could only seek an additional 6-year term. Once you're 70 years of age and an election date comes up, you finish your age limit. They put that out there, I don't know how many years ago, but it's been on the books for a while. And yes, I would. If I was fortunate enough to be elected, I certainly would. I love the law. I enjoy getting up every morning, going to my office, and helping people. We solve problems, and I've done it for 36 years now. 95%, maybe even more, the people that come into my office have never had an appointment. They come and they ask if they can see me, and more often than not, within 15 minutes, we're sitting down and we're discussing their issues, and we're talking about their problems, and we're trying to fix what might be wrong. Or if we can help them, we will help them. But I enjoy the law. I've been preparing for this job for 36 years now, and it's something I've always wanted to do. This was my last opportunity, so here I am.
All right, so this next portion is going to be 3 questions. The last 3 questions, one's going to be, or each is going to have a question tailored to your background, and then you'll have 2 minutes to respond, and the other 2 candidates will have 1 minute to add to that or comment on that as well. So we'll start, I guess, start with Lonnie, alphabetical order. As a primarily civil litigator, you presumably settle many of your cases prior to trial. Considering the limited resources available to the court and the large docket, how will you, as a judge, encourage parties to settle disputes outside the courtroom?
That's a great question, Arthur. One thing that is somewhat lacking in our judicial system is a solid pretrial order with deadlines and people being held to those deadlines. and a pretrial conference where the judge actually can sit down with the parties, if the parties agree, and talk about the case. Because when I first started practicing, that happened all the time. The judge would have a pretrial conference, and the judge would talk to the attorneys, and the case would settle. These days, the attorneys meet with the law clerk. I don't know how that happened over here in the 18th JDC. You don't meet with the judge at a pretrial conference anymore. You meet with the law clerk. But at a pretrial conference, cases can be resolved, particularly on judge trials, because you're going to be the one deciding the case. These cases with the $50,000 threshold. So if you meet with them in your office and they lay the case out, and they all being honest, and why wouldn't they be? They're going to tell you their best case, and the other guy's going to tell you his best case. You can give them an idea of what you're going to do, and they should settle the case after that. So solid pretrial orders, pretrial conferences can help resolve cases. What was the rest of your question?
Excuse me, that was it. So what possible solution as a judge, or what angle would you take to encourage?
Well, pretrial orders and sticking to the deadlines, because that happens too, where the deadlines are pushed back. Judge, we need more time. No, I gave you a deadline. The deadline is the deadline, and that's it.
So the question to Lonnie was, as a primarily civil litigator, you presumably settle many of your cases prior to trial. Considering the limited resources available to the court and the large docket, how will you as a judge encourage the parties to settle the disputes outside of the courtroom?
Again, as he said, pretrial conferences are important in that. And I mean, I think it's very important for the judge to be involved in pretrial conferences so that he can give the litigants his idea of what his opinion is when they tell him each side of the case. So again, yes, I think pretrial conferences are very important in reaching resolutions on cases and settling cases, because if you don't know where the judge is at, and if he's at the root, and again, this is on cases under $50,000 where the judge, it's a judge trial. How are you going to know whether you should settle your case unless you get a feel for where the judge is? And I think it's important.
And Lonnie was absolutely correct that back in the beginning, in the old days, that's what we did. You know, the judge participated in these bench trials and on these pretrial conference dates, and I would present my case, and the opposing counsel would present his case in chambers, and you know, we go from there. And more often than not, you were able to find some common ground, some middle ground, and we would resolve these cases. You're saving the court's time, the court's money, and I don't know what happened, but you don't see that anymore. If they don't settle it out in the hallway, and y'all have seen that if you've been in the court house, that's where they do the work now, and that's where they're resolving the issues, because the judge doesn't participate in these conferences anymore. You know, that's something I'd certainly favor. You know, let's return to those days. Let's get some work done. And many of these cases, more often than not, they were resolved that way.
All right. So the next question, Mr. Marino, you've had extensive experience with local governing bodies. You're able to appreciate some of the challenges faced by these groups on a regular basis. The expenses of the judge's office are ultimately funded by the police jury. How do you plan to balance the needs of the expenses of the office with the financial situation or challenges of the parish?
That's going to be a tough issue. You know what the financial situation is of the parish. You know, we're dealing with the jail at this point in time, and there's some controversy out there at this time. Who's responsible for the salaries of the local jail personnel, the police officers, and it's all about money. And again, you know, we need to be more efficient in what we do. I'm not so sure, and I haven't been doing it up here. I do bond forfeitures over in West Baton Rouge Parish, and we collect thousands of dollars each month on these bond forfeitures. I'm not so sure that they are being conducted over here. Lonnie may know more about that than I do. I know Lonnie's been involved in the asset forfeiture. Okay, but you know, that's if we're not doing them over here, and I'm not so sure that we are. We need to start that. We need to collect these fees that are assessed by the judge, and that's not being done in all instances. We got to do a better job monitoring with our probation personnel of collecting, seeing that those fees are collected. And you know, it's not a silver bullet. It's just a way beginning to approach it till the cavalry arrives, and hopefully when we get some of that 70% money, you know, that we'll be in better shape to address a number of these issues that we're band-aiding right now when we need to do some surgery.
I think it's about efficiency as well, but we also all have to work together. I mean, the judge has to be cognizant of the status of the police jury, parish council, and I think, you know, it comes up a lot in the juvenile system because, like, we have a juvenile that they were holding, and sometimes, even though I represent them, they should be held. And then a few days later, they'll be released. And I'm like, what happened? Why he got released? Well, they didn't want to pay the money to hold him. And I mean, I don't think that's good. I think if you have someone that's violent, somebody that needs to be off the streets, it shouldn't be an economic issue as to whether they're held or not. And but I do believe the important thing is for us all to work together, kind of as I said before, you know, with the youth and the problems. It's not going to be fixed by one of us as a judge, the juvenile problem. It's going to take the community. You know, it's going to take, you know, mentoring. It's going to take trying to get the parents back involved and rearing their children. Because as I said before, that's where most of your issues are in the juvenile, is you don't have guidance in it. And I think it's going to take working together.
So I think basically you're asking about money. So part of what I did for the DA's office is highway interdiction. And highway interdiction is when you seize drug money. See, the drugs go one way and the money goes the other way. The drugs and the money are never in the same vehicle. And so what I did for the DA's office, I worked closely with Aubrey St. Angelo in Iberville Parish and seized the money. They seized the drugs too, but we seized the money. And the good thing about that is that sometimes we had seizures over $1 million. And that money is split between the judge's office, the district attorney's office, the local sheriff's office. So that's one thing that can be more aggressively pursued here in Pointe Coupee Parish, because a lot of that drug money is coming down 190. I can promise you that, because the parishes, Calcasieu Parish, those parishes, they intercepted it before it gets to Iberville. It's a very lucrative business for Calcasieu Parish. So that's one thing that could be done to generate revenue for the parish, along with collecting fines more aggressively.
All right, thank you. And last question from me. Mr. Kimball, as the public defender, you're often able to foster a closer relationship with your clients and probably have a different perspective than most others, specifically as it relates to juveniles. In your opinion, and given the current landscape, what is the most effective way for the courts to reform those offenders and prevent them from re-entering the system either as juveniles or as adults?
It's pretty much squarely what I started with. You know, we don't have an active FINS program. It's about being involved with these kids. And you know, if we had a FINS program, we can get services in the home. As I said before, FINS is family in need of services. And you get counseling to help the parents and the children. The truancy program, I think, needs to really be pushed in this parish because it hasn't been. And I think that's a big problem. You know, it's all about, in my opinion, trying to help get these kids on the right path. And over the last 10 years, I've done that. You know, but no matter, even if you get them on the right path, if they don't have the guidance at home, they're going to reoffend. And that's why I think it's really imperative that we start trying to hold these parents that are not parenting accountable. And I think that's the answer in the juvenile system. I've been asked, oh, you really think it's going to work? I said, well, I mean, that's the only thing we can do different than we've been doing. I mean, you can put them in detention and they're going to come out. The max you can hold a juvenile in detention for a nonviolent offense is 9 months. He's got to come out under the recent juvenile reform. And you can only have them on probation for a misdemeanor for 1 year. And then if you hold them in contempt, if they violate your order, say they're on probation, On the first offense, you can only hold them for 7 days for offense in 1 year, 1 12-month period. And on a second offense in a 12-month period, you can hold them for 10 days in contempt. That's just holding them in contempt. You still have the right to revoke them if you feel that they're not doing what they're supposed to do, and they can go to OJJ. But once again, if it's not a violent offense, they come in right back. So that's why I think we really got to try and fix where they're getting off track. I mean, you can put these kids in detention, but if you put them right back in the same setting, they're going to reoffend. And that's why I think it's important that we work on trying to fix the home, you know, trying to make these parents accountable. I really feel if you get into these parents that aren't parenting pocketbook, I think they're going to start paying attention to where their kids are late at night. You know, if you hit them with some fines and say, you owe this much, and then they're not just going to be letting their kids run on the streets. I think they're going to be looking at where they at.
You know, I'm all for rehabilitation. But at the end of the day, my primary concern would be keeping the citizens of this parish safe so they can sleep safely at night without worrying about somebody prowling around in their backyard stealing their four-wheeler, which is a big, big problem in this parish. We know it is. And it's mostly juveniles doing it. It's mostly juvenile repeat offenders doing it. So the solution to that problem is when they are repeat offenders is to have them adjudicated delinquent. And the state has to take them in. If it's 9 months, great. That's 9 months they're not going to be stealing. We'll do them again another 9 months if we have to. They have to be taken off the street because primarily citizens have to feel safe and secure in their homes. That's the most important thing at the end of the day.
And I agree with that. You know, they're in our garages now, and the next step is through that side door into your home. It's called home invasion. Once they don't find what they want underneath your carport. But again, we're dealing with broken families here, drugs, and again, we got to get their attention. And like Lonnie, we both prosecutors, we are of the same mindset. You know, once you get to that second and third and fourth chances, at some point that's nothing more than enabling, and that's got to stop. You know, with the safety of our citizens is paramount, but we also have to take into consideration after that 9-month period they back out there. We haven't done anything to rehab these children. We need to spend more time in juvenile court with them. We need to figure out what's going on in their lives, what's going on in that 12-year-old child's life. And you know, more often than not, you're certainly dealing with broken families. You've got interfamily violence, interfamily crime, interfamily drug use. You know, once we figure out what's wrong, at least we got an idea of how to attack the problem. And we, you know, we owe it to those 12-year-olds to fix these problems if we can. If we can't, everything's on the table as far as detention.
All right. Well, with that, let's get to closing statements. You know, thank y'all again. We've had outstanding, I think, perspective, insight into the way that y'all look at this position. As or for the closing statement, maybe focus on what you think specifically separates you from the rest of the field in this race going forward. So let's try for 90 seconds on that for each person.
I was riding around knocking on doors yesterday with somebody I call my work wife, which is Angie Ramagas. And she does drug testing for the courts here. And she said, you know, it's not your years of experience, it's the experience of your years. And I'm the junior member here as far as length of time that we've been practicing law. But my background is much more diverse. I've handled more civil cases in this parish than these other two candidates combined. I've defended, I've prosecuted, I handle domestic cases. I'm in there every Wednesday, every single Wednesday on divorce cases. I've never seen either one of these two gentlemen. I like them both. I've never seen them in that room, ever. Not once. Maybe their practices are limited to transactional work. That's fine. There's nothing wrong with that. My work is courtroom work. I'm a litigator. That's what I do. That's what I've done my entire career. I'm in the courtroom. I have courtroom experience. I feel comfortable in the courtroom. I feel more comfortable in a courtroom than I do standing in front of you guys. I'm very comfortable there. So, touching on the juvenile issue, it is a hot button issue in our community. It's a problem that needs to be addressed. No more plea bargains. There needs to be trials, and some of these kids need to be adjudicated delinquent.
I guess this is where we take the gloves off, huh? They are adjudicated as delinquent. Anytime a juvenile comes to court, whether there's a hearing or not, the judge makes a finding and adjudicates them delinquent. And he makes the appropriate sentence, whether it be some form of informal probation, or whether it be formal probation, or whether it be just services in the home. The judge in the juvenile court system has a ton of remedies available to him, and one of them being detention if he feels the child can keep reoffending. But what separates me from my two friends here is my criminal courtroom experience. I've tried, as I started out, numerous felony jury trials. I've been capital case certified. I've tried first-degree murder cases. I've handled civil jury trials. And it's that time in the courtroom that I gained the respect of the other court personnel. You know, I've had a few questions of me during my campaign, and you're a public defender, you're going to be soft on crime. I'm going to do what needs to be done when it needs to be done. And at one point during my campaign, I was saying, I'm always do what's right. I'm always do what's right. And I said, you know what? I got to fix that. I'm going to always try to do what's right because I'm not perfect. And you have that vow from me. I'm going to work hard, and I'm always trying to do what's right. And I think it's my experience in the criminal courtroom that separates me, because over half of what our judge in the rule, because we handle everything. It's not like in Baton Rouge where they have civil docket judges and they have family court judges. We handle everything. And over half of what we do is criminal. And it's my experience in the criminal courtroom that I think better prepares me to be your next judge. Thank you.
And I started this 36 years ago. I've been an assistant district attorney for 34 of those years. I've represented a number of governmental entities. I represent the Chapala Basin Levy District, several municipalities. I've served as pro bono attorney for Fire Protection District number 4 in this parish. I've got thousands of hours of actual courtroom experience. I cut my teeth in divorce court, which I no longer do because I promised myself that if I could ever financially afford to get out of one area of the practice, that would be it. I finally was able to pay the bills about 20 years ago, and that's why, Lonnie, you haven't seen me. I moved on to governmental law. I'm spending it all right now. I've practiced, like I said, extensively at the district court level. I have extensive appellate court experience, and I've provided oral argument before our Supreme Court. I think I'm the only one here that has done so. I've served as a speaker at legal education seminars. I've handled just about every kind of case that came across my desk. I had to. I was a solo practitioner, and I had to pay the bills. And I didn't refuse much of anything other than frivolous lawsuits. But my experience is there. I've worked 36 years preparing for this job. I can do the job. I want to do the job. Thank you.
All right. Well, I think that concludes everything tonight. Again, thank you to the candidates for taking the time and taking the trip out here. And thank y'all for running the clean race that y'all are running.